I practice in Toronto with the law firm of Greenspan, Humphrey Levine. I am in my 6th year of practice and I am a Windsor grad, class of 2003. And I think the most significant development that relates to the Charter in criminal defense work came from a case called Regina and Stinchcombe. And that's a case in which it was recognized that an accused, in order to make full answer in defense, is entitled to have full disclosure. It put an obligation on the Crown prosecutors to provide to the defense any material that's at all relevant to the case. And that's any material that's either in their possession or within their control. So any material that's in the possession of the police. The defense are entitled to that. And I think in terms of, although some Crown offices were likely already following that type of approach when Stinchcombe came along, not all of them were. So it created a consistent standard across Canada in terms of disclosure obligations. And I was not practicing at that time before Stinchcombe. I can't even imagine what the practice would have been like at that time. I think it's impossible to recommend just one charter case to somebody who is unfamiliar with criminal law and the role of the Charter in criminal law, but I can give you an example of a case that I think is probably a good one, and that would be the case of Regina and Seaboyer. And I choose that case because it deals with the admissibility of evidence that the defense wants to rely upon. And what it was a constitutional challenge to the rape shield provisions as they existed at that time. The court ultimately found them to be unconstitutional. They've been redrafted and they now exist in a different form. But in that case, the court was balancing an accused right to make full answer in defense and an accused right to a fair trial against privacy interests of a complainant in a sexual assault case, for example. And at the end of the day, the court said that if you've got evidence that the defense wants to rely upon that's relevant, there must be substantial prejudice on the other side in order to exclude that evidence. So it just shows that there is, when there is a tension or a conflict between an accused's right to make full answer in defense and the right to a fair trial, that at the end of the day, that's going to trump any privacy interest that may exist.